Hey everyone, Donnie Icenhour here, and today we're covering Chapter 9, Basic Contract Law, one of the most heavily tested chapters in the North Carolina real estate exam. This chapter is all about contracts, offer and acceptance, valid versus voided contracts, consideration, statute of frauds, contract termination, and key exam traps you absolutely should know. But before we jump in, be sure to download the free worksheet in the video description below so you can follow along. Let's jump into Chapter 9. What is a contract? A contract is a legally enforceable agreement between competent parties. Now notice something important here. A contract is not just a promise. People make promises every day. A contract is what allows a court to enforce those promises. That is a huge concept to understand. But what are the essential elements of a valid contract? For a contract to be valid in North Carolina, there are several things required. Let's walk through them one by one. Number one, mutual consent. That simply means both parties agree to the terms. This is often called meeting of the minds. Both parties must understand and agree the same thing. Example, a buyer offers $400,000 for a home. The seller accepts exactly as written. We have mutual consent. But if the buyer changes anything like the closing date or the purchase price or earnest money or due diligence amount, that is not acceptance. That becomes a counteroffer. A counteroffer rejects the original offer and presents a new offer with different terms. That is very testable. Competent parties is number two. Both parties must have legal capacity. That means must be an adult, must be mentally competent, and cannot be intoxicated. Here's a big test point here. A contract with a minor is not automatically void. It is voidable by the minor. That means the minor can back out. The adult usually cannot. That's a classic question. Consideration. Consideration means something of value exchanged between parties. It's usually money, but it can also be services, property, promises. And so here's an example of that. Buyer promises to pay $500,000. Seller promises to transfer ownership. That is consideration. Now here's the important part. The earnest money does not create consideration. The promise to exchange value creates consideration. Legal purpose. For a contract to be valid, the contract must involve something that is legal. That means the contract cannot be for illegal services, fraud, crime, anything against the law. If the purpose of the contract is illegal, a court will not enforce it. For real estate, a seller cannot legally say, "Hey, I'll sell you this property if you help me hide defects of the property from the lender." That's the legal purpose. That is an invalid contract. So if a contract involves illegal activity, then the contract is usually void. Usually void. That means it has no legal effect. It is treated as if it never existed at all. Pretty simple. So the types of contracts in North Carolina, you need this knowledge, so let's simplify it. Express contract. Terms are stated clearly. They're written and they're spoken. Real estate examples are usually a buyer submits a written offer to purchase a home. So offer is $450,000. Closing date, June 30th. Earnest money deposit, $5,000. The seller signs and accepts the exact terms. This is an express contract because all terms were clearly stated in writing. Most real estate contracts are express contracts. Implied contracts, created through actions. An implied contract is created through actions instead of it clearly being stated in written form. A buyer walks into an open house and asks the agent, "Can you show me more properties like this one?" The agent begins to schedule showings, researching homes, and providing information. The buyer continues working with the agent, even though no written agreement was signed yet. The actions of both parties may simply imply a working relationship. Another real-world example is like you go to a restaurant, you order food, nobody says, "Will you agree to pay?" But your actions imply that you'll pay. Let's talk about a bilateral contract. Most real estate contracts are bilateral, and a bilateral contract is the most common type of contract in North Carolina. Think of bi means two. That means both parties are making promises to each other. In a standard offer to purchase, the buyer promises to buy the property and the seller promises to sell the property. Both sides have obligation. The buyer promises pay the purchase price, follow contract deadlines, and complete the due diligence. The seller promises transfer ownership, deliver clear title, follow the terms of the contract. Because both parties are promising something, the contract is bilateral. A unilateral contract. A unilateral contract is one side promises. That means only one party is legally obligated to perform. The second party is not required to act unless they choose to. For example, an open listing is a great real estate example of a unilateral contract. A seller tells several agents, "If you bring me a buyer, I will pay you a commission." The seller is promising payment, but the agents are not required to find a buyer. The agents are not obligated to perform. Only the seller made the promise. This is a unilateral contract. An executorial contract. This is the most important vocabulary word for the real estate exam. Executorial. Executorial. Executorial means the contract is not fully executed yet. There are still obligations remaining. Executorial contract equals obligations still remaining to be done. A buyer and a seller sign an offer to purchase contract, but the home inspection has not yet happened. The loan is still being approved. Closing has not yet occurred. The deed has not yet transferred. This means the contract is executorial. Executorial. Why? Because both parties still have things they must do. The buyer must still obtain financing, deposit earnest money, complete due diligence, bring funds to the closing. The seller still must transfer ownership, deliver clear title, promise or complete agreed repairs, and close on the property. Since obligations are still remaining, the contract is executorial. Executed contract. That means executed means fully completed. Executed contract is a fully completed contract. Once closing occurs, deeds transfer, money is exchanged, all obligations are completed. The contract becomes executed. All parties have fulfilled their obligations of the contract. So let's talk about offer and acceptance. This can be the most tested part of Chapter 9. So let's slow down here for a moment. The offer or and the offeree. In a previous video, we talked about the offer or gives. Offer or gives. Offeree receives. Offeree what? Receives. Exactly right. So the offer or is the person making the offer, usually the buyer. Offeree, receiving, the person receiving the offer. Receiving the offer, and that is usually the seller. So an important exam rule here. Acceptance occurs when the offeree signs the offer exactly as written. But, as we mentioned earlier, a contract is not fully formed until communication of acceptance. This is huge. A contract is not fully formed until communication of acceptance. So let me explain. Buyer submits an offer on Monday. Seller signs Tuesday morning. Listing agent calls agent Tuesday evening and says the seller accepted. Contract formed, not when the seller signed. The contract formed when acceptance was communicated. That is one of the most common exam questions that you can see. Now remember, a counteroffer rejects the original offer. Let's jump in for a moment and talk about Statute of Frauds. North Carolina real estate contracts must be in writing. This is called the Statute of Frauds. In North Carolina, contracts must be in writing because of the Statute of Frauds. Not in writing, not enforceable. That includes sales contracts, option contracts, and leases over 3 years. Statute of Frauds, real estate contracts must be in writing. So let's talk about voidable, and valid contracts. You must know the difference. A valid contract meets all the legal requirements, and that is enforceable. A void contract never had legal effect. For example, it was for a legal purpose. So void means treat it as if it never existed. Voidable contracts appears valid, but one party can cancel. An example could be going into a contract with a minor, or it was fraud, or went under contract because of duress. That is voidable. That can be a big exam topic. Let's talk about misrepresentation and fraud. Misrepresentation and fraud. Willful misrepresentation, a person knowingly lies. A seller agent knows the basement floods, but says no water issues. That is fraud. Negligent misrepresentation. Person didn't intentionally lie, but should have known. Still had a problem. Brokers can absolutely get disciplined for negligent misrepresentation. Discharge of contracts. How do we do that? How do contracts end? There are several ways. The best one is fully performance. Most common. Everybody does what they promised. Closing occurs and it's done. Could be by mutual agreement. Both parties agree to terminate. Could be by operation of law because of bankruptcy. It might also be because statute of limitations. Now, a breach of contract, that is when one person fails to perform. That creates legal remedies. And so a breach of contract happens when one party fails to perform their contractual obligations. A buyer and a seller under contract for a home. The buyer removes all contingencies, have financing approved, and is ready to close. The seller suddenly decides, I changed my mind. I'm not selling. The seller has breached the contract. The seller failed to perform what they promised to do. So let's talk about contract remedies. Specific performance. The court orders someone to perform. Usually used in real estate because every property is unique. Seller refuses to close. The buyer may sue for specific performance. Liquidated damages. That's predetermined damages. In North Carolina real estate, earnest money is often liquidated damages. If the buyer backs out after contract, after the due diligence period, then the earnest money goes to the seller as liquidated damages. If the buyer backs out of the contract after the due diligence period, then the earnest money goes to the seller as liquidated damages. before we wrap up, let's hit on some key exam traps. Trap number 1. When is a contract formed? When is a contract formed? Not when seller signs, but when acceptance is communicated. Trap number 2. Minor contracts are not voided, but they are voidable. They are voidable. Executorial means contract not fully completed yet. Contract not fully completed yet. Trap number 4. Counteroffer does what? Counteroffer does what? Rejects the original offer. And trap 5. Statute of Frauds mean? Statute of Frauds mean real estate contracts must be in writing. All right, everyone, that was chapter 9. Contract law, offer and acceptance, valid versus voidable, consideration, statute of frauds, contract remedies. This chapter is extremely important for both the exam, but also real-world real estate life. And trust me, you will use this knowledge every single day in your real estate career. Thank you so much for watching today's video. And again, if you want the worksheet, you can download it in the video description below. Please don't forget to like the video, subscribe to my YouTube channel, and then follow me on Facebook. If I could ever be of any assistance to you in any way, I am always here to help you from licensing to close.